So in this case, it was Compass Group and the National Union of Workers and the United Fire Workers Union. The Compass Group terminated a group of employees that had been working on Department of Defence contracts in hospitality and catering. They refused to re-tender for the contract, and as a result they terminated a group of employees because they obviously didn't need them to work on that contract anymore. A part of the enterprise agreement stated that if employment is terminated due to the ordinary and customary turnover of labour, which reflects the Fair Work Act, redundancy payments did not need to be made. So the Compass Group refused to make redundancy payments, and the unions brought action against them in the federal court, claiming that redundancy pay should have been made. What was interesting was that Compass Group produced evidence that 54% of its employees had been dismissed as a result of the loss of a contract in the previous 12 months. At first instance, the Fair Work Commission found that the employees should have been paid redundancy pay because they had a reasonable expectation of continuing employment. There was nothing in their contracts that specifically said that their employment was tied to the continuing of the contract. This was going to present a significant burden to Compass Group because they regularly terminate employees at the end of contracts. So if they were required to make redundancy payments to all of these employees, it would be a significant amount. They appealed it to the full bench, and the full bench disagreed with the Commissioner's initial decision and found that there was statements in the contract that tied their employees' employment to the Department of Defence contracts, and found that the situation was one of ordinary and customary turnover of labour, and the employees weren't entitled to redundancy pay.
I thought it was a really interesting and somewhat surprising decision, given that there'd been extensions of contracts with the Department of Defence. I think it's going to throw a lot of companies that rely on government contracts into considering, well, do they now have a potential to not have to sit there thinking about redundancy payments if their contract's brought to an end, and what sort of measures are they going to have to put in place? I mean, obviously, in this particular case, there'd been some extensions. I don't think they said exactly how many, but you know, if there was 5 extensions versus 2, would that change things? If there'd been a lower percentage of employees that had been terminated at the end of the contract, would that change things, and would they then be entitled to redundancy pay? So I think it could have some really interesting ramifications.
Yeah, I think one of the disturbing potential issues arising from this is scope to allow companies to use more labour hire companies for short-term contracts, because if in fact you can say, well, the ordinary and customary turnover of labour for this company, Compass in this instance, but say a labour hire company, is very high, it allows in effect a form of what I'd almost consider sham contracting to take place, where you have companies that are set up in effect to employ the employees specifically on a period while the contract is in place. I wouldn't be surprised to see some case law or legislative addressing of this, and in particular some pressure for government contracts in the tendering processes to specifically require the redundancy be paid. Because as I say, it applies to a very vulnerable group of workers, and in effect it is a way for quite long-term workers to end up without redundancy benefits when, for no fault of their own.
Also, I think it's relying on the termination, change and redundancy case from 1984, which obviously there's been a lot of years that have passed since then, and government contracts are very different. A lot of these services were provided in-house by government back in 1984, not externally by private companies. So I think that's a significant difference.
Anyway, it will be interesting to see what occurs, because I'd be very, very surprised if the ACTU sit back and just accept that this is a new way that employers can avoid their redundancy entitlements.